How does or how should your estate plan change when you decide to get remarried in your retirement years? Welcome to another episode of the Simply Retirement Podcast. I am your host, Eric Blake. Whether you're a woman that is single by choice, by divorce, widowed, or if you're just simply ready to take control of your financial future, the Simply Retirement Podcast is for you. For all the links and resources for this episode, you can go to www.thesimplyRetirementPodcast.com/41. Our guest today is Amy June. Amy is an estate planning attorney and owner of June Law Group. Estate planning should always be a critical part of any complete financial and retirement plan, but there can be some significant decisions that need to be made if you're getting remarried. Today, Amy's going to share her insights on this topic. Amy June, welcome to the Simply Retirement Podcast. How are you?
I'm doing great. Thanks for having me.
Absolutely. I'm so excited. You and I have had conversations. We're a part of some the same networking groups, and I've really been looking forward to this conversation. If you don't mind, let's just start with your background and ultimately, how did you get into estate planning? I found over the years, I found there's always a good story behind how people decide to get into estate planning.
You know what, in all the stories I've heard from other colleagues of mine, it is usually a pretty interesting story, and people usually have a pretty personal reason for it.
Mhm.
So I started out, I was actually a CPA in my former life, briefly after college. Grew up in California and went to UC Santa Barbara, graduated, moved to LA, and was a Big Five CPA for 3 years. Knew pretty soon that it was not a long-term thing, that wasn't quite the right fit for me. Still glad I did it. I met my husband there, and he did stick with it. But I then went to law school at Duke, and then focused when I graduated. I interned at the Justice Department in their tax division and loved it, like that, investigating financial fraud and get really diving into those things and solving the hard problems and figuring those things out. And it led to, then when I graduated, I went to work for a huge, big international law firm and worked there for quite a while, um, doing securities litigation and defending accounting firms, defending businesses in, really large scale, like SEC investigations and that sort of thing, and class actions. So I did that for a long time. It was litigation, but it was sort of that, like, figuring things out, not a lot of sort of stand up in court and really arguing in like a adversarial way, but there was still a lot of arguing. And then as my career progressed, so that was 23 years ago that I graduated from law school. And then, especially after I moved to Texas and I was still doing litigation, and I just was so sick of the fighting and of the feeling like I was cleaning up messes after the fact. And I just don't like to fight. I like to solve problems. And I realized I really wanted to focus on um, solving problems or creating things ahead of time that would avoid that really horrible court process and all of the, the cost and the just pain of going through it for me and for, obviously my clients. And what led to estate planning, one of the big things was I realized when I was really looking at getting out of litigation was that the ugliest fights by far were the ones where there either was no estate planning, like, or it was not effective, and between family members, between loved ones, when something happened. So when, mom or dad died or whatever, and those fights between it ruined families. And a lot of times those fights in court would drain estates. So people would end up with nothing or with a lot less and with a ruined family. So I realized it was an area that I could really do, with a lot more flexibility in my schedule as well, and not being beholden to the court, but also really do a lot of good and avoid a lot of pain. And so that's what I focus on now is really helping people to understand, and then implement things where they can avoid that court, avoid the conflict, or at least minimize it as much as possible.
That's perfect. Again, there's always a good story. I always love to hear the stories when how attorneys get into estate planning, especially if they've been in some other form of law where
Right.
they didn't enjoy it as much or they just didn't have the same passion. But that's
Yeah.
where estate planning is always there's always a passion for helping people behind that move. And we've actually been joined by a couple of great estate planning attorneys in the past on past episodes. I think you even may know both of them. Chris Downs was on episode 18, really just talking about the basics of estate planning. Susan Barnett joined us on episode 22, talking about the difference between wills and living trusts. So I would encourage our audience to go back and take a listen to those just to cover the basics.
They're great. I listened to both of them leading up to this because I wanted to,
Thank you.
and I know Susan well, and Chris I don't know as well, but she's, what she covered. Both of those have some really great foundational things, so that we can then dive into some follow up without having to go through it all.
Yeah. So if you wouldn't mind, just to cover the basics, just kind of what are the basic estate planning documents that people need to be aware of, and then we'll make a move into some of the more strategies related to remarriage.
Right. So, what is an estate plan? I always find it's sort of that's the starting point and it's how you yourself and your stuff is managed when you're alive and can't handle things for yourself. So, incapacitated in whatever way, dementia or a coma or, that those kind of things where you can't do it for yourself. That's part of an estate plan, which a lot of people don't think about or realize. And it's how you, because there are end of life choices and those sorts of things, and your stuff is managed and handled, who it goes to, how it goes there when you die. So that is what it is. And I always think of it not really as the documents, but it's the overall those two things. The documents that make that happen are, there's a core set of documents that everybody should have. But there's a thing called probate. And I know that has been gone through before, so I won't, go through the details of it. But basically, it's the court process that your loved ones have to go through if you die with anything in your name. So if you own anything personally when you die, your loved ones have to go through it. It's to determine, do you have a valid will or not? Who is going to be the person who winds up your affairs and handles them? It's called a personal representative or an executor. You may have heard both of those terms, but that's who that person is. And then it just deals with paying off any debts and all of those kind of things. And then who gets whatever remaining money is left after all that stuff is paid off. Who gets your money? Who gets your property? So that's what probate does. There's some drawbacks. It's time consuming. It's expensive. A judge is making decisions. It's public, and especially, and I know this was covered before, and currently now it's very easy to get that public information. So there's identity theft concerns, but also, taking advantage of your loved ones, especially if you've got younger loved ones, children or young adults. And this is where I sort of laying a little bit of the groundwork for later in our discussion, is that going through probate significantly increases the chances and the extent of fights, of disharmony between your loved ones. And one of the reasons is, a big reason is, there's already a court case. So if there's a court case already going, right, and that's what probate is, it's a lawsuit, then you've got a disgruntled cousin, brother, son, daughter, whatever. They don't have to go to court and file their own lawsuit now to challenge whatever they think should or shouldn't have happened, or because they're mad at their brother who's the executor. Now they just join the one that's already there. So it's there's a much lower barrier to entry for somebody to cause a lot of problems. So that's something else that I mentioned, is that it lays the groundwork to increase, that disharmony, that discord, and the chances of really, like I said, like destroying families, or at least really causing a lot of problems.
I know, honestly, I've never heard it described that way, and I think that's a great way to think about it. I think to get the point across of how important it is, if you just understanding what probate is, but what's really involved, I think describing it like that is a great way to think about it. The urgency of, hey, number one, let's get an estate plan done. Let's make sure you at least got a will.
Right.
At least makes the process a little bit easier. But just thinking about it, that again, that there's a court case that's there, people just hopping in.
This is a court case, and I have not talked to one person who has been the executor, who's been the personal representative, and who's gone through probate, um, who says it was a pleasant experience. It is not fun. And it freezes assets until it's completed, so your beneficiaries don't get them. So there's a lot of things. So I say this because asking about like what the documents are. Probate is what you go through if you have a will or you don't have a will. So avoiding probate is not a priority for everybody, but one of the fundamental things that I always do is educate people about what does probate look like in their particular situation, the specifics of it. We're in Texas. There's a lot of people who consider it a quote probate friendly state, and it is compared to, I also practice in California where I'm from. And that is the case in terms of a couple of things. It is a relatively shorter process, and it is a lot less expensive for a lot of people, depending upon, how complicated everything is. But California is extremely expensive. So when people are thinking of Texas, they're like, oh, it's a lot cheaper. Well, but that's not the only consideration. And it's certainly not free. So that's where I always make sure people understand and I tell this to them, in your particular situation, what does it look like? And so that then they can decide for themselves, is a will-based plan the right thing for them? Or do they want to avoid probate and create what's called a revocable living trust-based plan, which I know Susan went through what that is and how it works, but it basically pulls everything out so that you now no longer own everything in your personal name. Because if you own anything in your personal name when you die, a probate case has to be opened because you own it and a judge has to sign off on where that goes. So the key is if you want to avoid probate, is to remove things from your name. Make sure that you don't own anything personally. And the main way to do that, the one that is, the main way to do that is with what's called a revocable living trust. And what that does is it keeps you in control of all of your assets while you're alive, but it allows somebody to step in if you're incapacitated. You own him while you're alive as the trustee of your trust, but you retain all control, do whatever you want with them. But if somebody, if you're incapacitated, can't handle it yourself, or when you die, a successor trustee steps in, now nothing to do. There's nothing for the judge to do. So now the trustee handles everything and decides who gets paid what and does all those things that the court would otherwise do, but at much faster, much cheaper, privately, all of those things. So the key documents are a will always, because you always need that as a backup. For many people who want to avoid the drawbacks, who want to avoid probate, it also includes a revocable living trust. It may include other trusts layered on, and we'll talk in a little while about some of these things that somebody might want to consider. But, in certain circumstances, but also includes all of the healthcare documents, instructing, giving power to people to make healthcare decisions, powers of attorney, guardianship documents saying who's going to raise your children long term, and also who could take emergency custody of them to keep them out of the hands of, foster care or the police, et cetera, in an emergency, which a lot of people don't think about, is that, somebody needs to have legal authority, and they need to have a piece of paper to show the police to say, I can have custody of this child. So those are the main ones. Is really all of those things. So to have that in place, and I think it is very important for whatever that group of documents are to be customized to your particular situation, so they will actually work when you need them to.
Perfect. So let's start looking at how we can transition into a little more of the conversation on the considerations for remarriage. Now, our practice, we focus on retirement planning for women over 55. We have clients that have been widowed, that have gone through a divorce at some point in the past. We also have clients, of course, that are single by choice. But I want to share just a few stats really quick with our audience, because I think this just drives home the point of when you're considering getting remarried or getting married in your later years. you really need to be aware of some of these strategies and planning ideas, because one of the things that always astonishes people is you think about becoming a widow. The average age of a widow in the United States is 59 years old. You also think about the divorce rate for people over 50 has doubled since the 1990s, and women over 55 are actually more likely than men in that same age group to initiate the divorce. And that's like just looking at some of the reasons that I've done the research on. A lot of times is due to just their personal goals have changed, that they just a desire for independence, dissatisfied for any number of reasons with a long-standing marriage. But almost every year we have a conversation of two with our clients that say, hey, I'm thinking about getting remarried. What do I need to be aware of? What do I need to think about? And that's really what I want to get your insight on. What are two or three of what you would consider some of the biggest challenges or decisions from an estate planning perspective when people are getting remarried later in life like this, where they have an established life, they may have adult children,
Right.
they may have a house, they accumulated a good amount, and our clients in many cases have accumulated a good amount of investment assets or retirement assets. What are some of the things that you see that are a challenge or that they need to really be aware of before
Yeah.
they make that, but hopefully before they make the decision to get married, but at least in preparation for or shortly thereafter?
Right. Right. No, that and I'm glad you're having those conversations with your clients. And um, yes, there are some very distinct challenges and different planning considerations when you do have a blended family, when you do have a second marriage, when you it is later in life and you're not coming in fresh, to 20 something or 30-year-old, don't have anything but their, dreams and build something together, right? Where everything is starting out together. So I see um three big issues, but and we'll talk. I think we may talk about the third one, or not issue, but sort of how to deal with the third one in a minute. But the two biggest ones, as far as like really planning and the logistics and what you really need to focus on and that complicate things, um, are, like you said, a lot of times, like your clients have existing property. They've got a lot of stuff already. So it's dealing with those existing assets that each spouse brings to the marriage, right? So that's one, that's a big one. And the other one is kids. What we call it, a blended family. It's the yours, mine, ours, the Brady Bunch thing, right? Like that sounds all
Right.
happy go lucky, but like that can cause some serious complications and just a lot of different, yeah, the things you need to deal with differently and deal with thoughtfully, in order to avoid huge challenges. So the first one, dealing with existing assets brought to the marriage, estate planning, a lot of how things are handled, and a big difference between this later in life versus earlier where everything's together is in Texas, in some other states, it's a community property state. So what I'm talking about, it has broader application, but it really, really focuses on, in a community property state, assets you bring to a marriage and ones you inherit and ones that are given to you as a gift are your separate property. In Texas, there's a presumption that all assets are community property. Well, now, if you've got two adults who are now bringing significant separate property, you now have to think about and plan for, do you want to keep it separate? Do you want to make it all community? And those decisions have significant impact on what happens and what you can do to leave your assets to your heirs. And certainly, if you have not done any planning and you die what's called intestate, without a will, without saying who gets your stuff, the state of Texas has, a plan, a will for you. It's very rigid. And I want to talk about in a little bit, we'll talk about what that does and that there's some huge surprises. So, just logistics wise, living with the separate property, the community property, how have you been living so far? Do you have stuff that's yours and you want to keep it yours? Do you have your own kids and you want to be able to funnel it, directly to them, to grandkids, that sort of thing? So there's much more of a his, hers, and ours money situation. So that is a huge challenge. Um, Not a bad thing. I mean, got a lot of money and you're bringing it in. It's not a bad thing. It just does matter how you handle those things. So, um, the strategies for, and this is big picture, really don't want to get into, try not to get into the weeds, but um, when I counsel people on um, deciding how they want their plan structured, big picture, when they are married, is the first question they have to make is, how do I want things to happen, or how do we want things to happen when the first spouse dies? So there's two kind of main choices. One is to leave everything outright to the surviving spouse, and then they're in charge, right? If you do that, now the um, surviving spouse is in charge. They can decide to leave that money to whoever they want, and they're in charge of all of the money. The second thing you can do is um, how you have things set up ahead of time, like when you're doing the foundational planning. Most people in Texas, in other community property states, it makes sense. And we usually always set up a joint trust for a married couple. You can also, if you do have significant separate property, you could set up a joint trust for what you own together, and then two separate individual property trusts for your separate property. And now, if I am married to, my husband, and we have two separate property trusts for our own stuff, mine is governed entirely by me. I make all the decisions about what happens with all of it, but I also individually decide how that gets passed on, who the trustees are after me, who gets all of that. And so that is handled completely separately. His is handled completely separately. And then jointly, we then can decide, you know, maybe we leave all the community property, like everything, to the surviving spouse in the joint trust. And what that sort of mix looks like probably really depends on a couple's financial situation. You can also keep your separate property, just have a joint trust, but maybe you have less significant amounts of separate property coming in. Or maybe you um, overall want to leave the assets in a similar way from your separate property, but you can put it all in the joint trust and then make sure that you are handling it in a way that you don't accidentally um, turn separate property into community property, which can very easily be done by commingling it in a bank account, spending it on, I spend my individual bank account money that's my separate property on our joint home, that sort of thing. Like there's ways to do that. So that's sort of strategies to consider. So it's the planning at the first death. Then it's also considering his, hers, and ours trust from the outset. So that's kind of the high level of that, if that makes sense.
Yeah, and I think the main thing you and I have talked about is that to take away from for our audience is just know that the number one, you need an estate plan. That's number one. Let's not jump over that. But number two is there are strategies, but you need to sit down with a qualified attorney. Obviously, there's all these different online options, but when you're talking blended families, the complexities in almost every single case, the complexities are not for an online platform. You need to sit down with an attorney.
Well, and it's not for going to an attorney who's and this term, trust mill, where you're walking in and they're like, all right, fill out these, well, do this, pay me $1,000 and I'll quote, do your plan. That's not personalized for your particular situation. And in this blended family situation, this is not a simple situation. And the implications of not having your plan tailored for you can be huge, right? For, yeah, are very, very significant.
Well, let's talk about a couple of specific strategies because I think you've done a great job of just outlining the fact that again there are strategies, there are solutions. You just need to sit down with somebody who's qualified to understand and talk to you about your situation. But a
Hmm.
couple of specific topics I wanted to make sure that we talked about. One is, what are your thoughts about prenuptial agreements? How does that fit in? We always hear, you almost hear that it's always on the news with celebrities and things like that. That's where you hear about these, but they can be a lot more. They can be effective for other situations. For you and
Right.
I, for whoever it might be that might be in that situation.
Yeah.
Just a little bit about what a prenuptial agreement is. Where might it fit?
A prenuptial agreement is, um, there, I mean, it fits within this sort of broader classification of agreements where you are agreeing between yourselves how your assets are dealt with um, during a marriage. You could do a prenuptial agreement. You could do a postnuptial agreement. And there's documents that we do as part of just an estate plan. If you want to just say all of our stuff is community property, you can do that, and that's in just a very easily agreement too. So that's kind of, those are the three kinds. So you don't have to do it before marriage as a prenup. You could do a postnup. Most often it's before, or a lot of times it's before because it's sort of part of that, like we're going in. They're much more common in second or third or, further marriages, um, to clearly define your property rights prior to your marriage. Um, and they control during your marriage, and then they control when somebody dies. And so it's important to consider them. I think they're smart. I don't want to say always, but in these situations where you are coming in with a lot of pre existing things, people, a life you've built. So that one of the things is it just causes a lot of couples don't talk about the important money, family, you know, those things prior to marriage. Hopefully, especially later in life, maybe you would be more likely to do that. And this gives a structure and it takes away the ambiguity, and it really forces people to think that through. Especially, and I didn't mention I heard this term, I actually just saw it and I think it's perfect. It's the Cinderella scenario, where you've got um, a family with, you know, children from both marriages or from prior relationships. Um, what happens to the estate when one person dies? It forces to think this through and document it so it's locked down, um, what's going to happen. So, without proper planning, we all know Cinderella, the dad died, Cinderella's dad died. Everything went to the stepmother, which was that scenario that we just talked about, where now she has all of the control. Cinderella, I mean, she basically enslaved her, but she also, I imagine, she also was not taking care of her in the way. She was using all of Cinderella's dead dad's money to take care of her daughters. And when stepmom died, guarantee you she was going to leave everything to her daughters and cut Cinderella out completely, right? So now Cinderella's dad's money is now going to the horrible stepdaughters, even if they're not even if they weren't horrible, they're not his kids. He has no relationship to them. So often when married couples leave everything to the first spouse, um, in a blended family situation, that can be really disastrous because the surviving spouse can literally very easily disinherit the first spouse to die's children and leave everything. And I can tell you, I can't imagine a situation where that's what that first spouse would have wanted, right? So now add in, you've got significant assets, tying those things down of here's how we want to keep things in this separate property, community property, and that this is what they are. It just layers that extra layer of protection and guidance and really thoughtfulness on top of then doing the estate plan, where now you're saying, here's where my separate property, community property goes. So I think, it really is these same two situations. It's, do you have a complicated family situation of multiple, kids from multiple marriages or relationships, um, significant assets, so that it protects everybody. So I think those are the main ways that it is important. And just if people want to be very thoughtful going into a marriage, which I think is smart, um, about how they want things to happen.
No, that's perfect. And I think I want to throw in one more thing, and you and I have talked about the importance of this as well. Is beneficiary designations and making sure that your estate plan and your beneficiary designations align. One of the biggest things, and I think this falls on the shoulders of the financial advisor just as much as it does the client, and just having a process for reviewing beneficiary designations and
Yes.
making sure that those are getting reviewed. And in our practice, we have a process every 2 years. We send out, here are your current beneficiary designations. Is there anything different? Has anything changed? Is there anything we need to be doing to make sure these are correct and accurate? And again, align with your estate plan. So I think beneficiary designations, just like you said, if you don't update those, we've all heard the horror stories about ex-wife gets this because the husband didn't change his beneficiaries, or
Yeah.
any number of those types of stories. So that's also, I just, because beneficiaries don't always get considered as part of an estate plan, but they very much are.
It's a huge part of an estate plan. They don't, I don't know if some of the confusion is that people, because beneficiary designated assets are non-probate assets, so they don't go through probate because you have an agreement with a company that, and that contract says where things go, right? And that's the beneficiary. And if you have not named one, then there's default rules. The contract says if you haven't named anybody, or if those people are dead or whatever, here's where it goes. So there's the reason it doesn't have to go through probate is there's nothing for the judge to do. There's nothing for them to figure out because it's all laid out there, right? Different types, there's life insurance, there's a whole variety of, investment um, type, retirement
Right.
accounts.
Yep.
They all have their own rules and different things that would happen if, for example, there's some that if you got divorced, your ex-spouse would not get it because of the type um, of asset that it is. But many, they would still get it. And I guarantee you that that's not what was intended, right? And you're very much in line with me. And the way I practice is I check in with everybody, all my clients every year, just on an email saying, here's this long list of bullet point things, like have things changed and here's what you need to look at. And if so, hey, reach out to me. And then I proactively a 3-year review of your plan, including beneficiary designations. Has somebody had a baby? Has somebody died? Did you move? All of those things, because um, it is so important that they stay updated and that everything stays updated. Another thing that, yeah, I mean, has one of your beneficiaries died, right? Like, and now who do you want it to be? Or do you like, because most people probably don't want it to go to the default that the company has. Um, does it still line up with your overall plan, right? Because, for example, if you have minor children, we usually recommend that the primary, or usually the contingent beneficiary, primary if you're married, be your spouse beneficiary, and that you always have a contingent, and that the contingent be your revocable living trust. Because first of all, with minor children, they can't inherit outright. I know that's been covered before. And so if they are the contingent beneficiary, which is very common, and this is something I see, like people come to me all the time and they have their minor children named as the contingent beneficiary. Now the court's going to get involved again, name a guardian to be in charge of that. It's not the person you've chosen. it's somebody else, and now they're under supervision, and those kids are going to inherit that money outright, which is probably something you've tried to avoid with the rest of your assets, because it's a really bad idea for, children to inherit money outright at 18, 21, you know, and now you've got them as your contingent beneficiary. That's what's going to happen. Um, and so there's that. So have they become adults? Do you now want to leave it to them directly and not into the trust? There's a whole, different considerations. But the other thing is, when you're looking at the big picture of your plan, if you've done all this planning we've talked about, especially now talking about a blended family, his, hers, ours, whatever, if you put an individual, one child, as the beneficiary of, one of your investment account, one of your IRAs or something, maybe when you first created the plan, you're like, all right, my trust does this, and then I'm splitting up my, beneficiaries so they're all getting basically even, and now it all works. A couple of years go by, that might not be the case, right? So now maybe, one child, because they're the beneficiary of this one account that's done really great or whatever, is now getting a lot more than one of the other children. Now, especially you bring in stepchildren and mix, like that can get out of whack really, really easily. So it is really important to make sure initially and as time goes on that you're looking at your estate plan as a whole and where you want things going and how you want them to go. And then to layer on one more thing is, do you want your beneficiaries to be receiving their money outright? Or do you want it to go into the trust where many people build in protections where instead of receiving the money outright from the trust, at stages or all at once, um, the money stays in an asset protected trust for them for their lifetime, and they can have control of that, but still have asset protection, maybe protection from, if there's drug addiction, if there's, other issues, you can build in different layers of protection so that, um, most people, the statistics are huge of people inheriting money or, winning the lottery or whatever, and it's gone within a couple of years. And it's a big way to avoid that happening. So, there are a lot of different things that you want to think about. And if what you want is a plan that's going to work to achieve your objectives, you have to keep looking at it as a whole to make sure it's still doing that. And one of those things is making sure your beneficiary designations are kept up to date.
That's excellent. I appreciate you sharing all that. Want to make sure that our audience can connect with you if they're, and I know there's going to be people that are listening to us right now or watching us on YouTube that and want to review their estate plan or they're thinking about getting remarried. How can our audience, we spit that out. How can our audience connect with you and learn more about your services? And I think you did say throughout our conversation which states you work in, but just to clarify, which states can you actually do estate planning?
Texas and California. So I serve clients virtually throughout Texas and California. I am actually based in Dallas, but I have 5 years of serving people virtually throughout. And so yeah, they can reach me. My website is amytheattorney.com. And I'm on Instagram, the Amy June, and LinkedIn, which I'm learning. I'm getting better at LinkedIn, but I do think it's a great resource. And they can email me. It's amyjune@amytheattorney.com is a really easy way to reach out. And I would love that. I want to throw one more thing in here, and we're not going to cover it in detail, but I will provide the basics for you so that you can maybe put it with the podcast or
Okay.
whatever. But I can almost guarantee you that if you die without, if you follow the state of Texas's plan, at least for you, some really bad things that you are not anticipating happen will happen as far as who's getting your money, including the surviving spouse may have to share their personal home with their stepchildren. So I just throw that out there that like it is a weird and convoluted like thing, and it's very rigid and you don't want it. So that if you just want to put one more thing on like
Hey, that's perfect.
why you need an estate plan is that can pretty much guarantee you do not want to be sharing your home with your stepchildren.
That is right. Well, this has been so helpful. Yes, we'll definitely share the links in the podcast summary. Amy, thank you so much for joining me today. If you're thinking about getting remarried, or if you're now remarried but you need to get your estate plan updated or reviewed, please be sure that you reach out to a trusted estate planning attorney in your area. If you are here in Texas or in California, please consider having a conversation with Amy. If you need help finding a trusted estate planning attorney in your area, feel free to reach out to me personally at eric@blakewealthmanagement.com. We are very well connected with professionals all over the country. Again, for all the links and resources for this episode, please visit www.thesimplyretirementpodcast.com/41. As always, please like, follow, and share the show. We will see you on the next episode of the Simply Retirement Podcast. In the meantime, please remember that retirement is not the end of the road. It is the start of a new journey.
That's it for today's episode of the Simply Retirement Podcast. We hope you found our insights and advice helpful in planning for a fulfilling retirement. Don't forget to take action on what you've learned today. Visit our website at blakewealthmanagement.com to learn more about our firm and review our Simply Retirement Roadmap process to get you on the right path to the retirement you deserve. And don't forget to click the follow button to be notified when new episodes become available. Thank you for joining us on this journey, and we look forward to helping you achieve your retirement goals. Remember, retirement is not the end of the road. It is the start of a new journey. So embrace it and make the most of it. Until next time, take care. Content here is for illustrative purposes and general information only. It is not legal, tax, or individualized financial advice, nor is it a recommendation to buy, sell, or hold any specific security, or engage in any specific trading strategy. Results will vary. Past performance is no indication of future results or success. Market conditions change continuously. This commentary reflects the personal opinions, viewpoints, and analyses of Blake Wealth Management. It does not necessarily represent those of RFG Advisory, their clients, or their employees. This commentary should not be regarded as a description of advisory services provided by Blake Wealth Management or RFG Advisory, or performance returns of any client. The views reflected in the commentary are subject to change at any time without notice. Advisory services offered by investment advisory representatives of RFG Advisory, a registered investment advisor, Blake Wealth Management, and RFG Advisory are unaffiliated entities. Advisory services are only offered to clients or prospective clients where RFG Advisory and its representatives are properly licensed or exempt from licensure. No advisory services may be rendered by RFG Advisory unless a client agreement is in place.